Understanding the difference between hold harmless and indemnify clauses can be crucial when signing contracts. These legal terms might seem similar, but their distinctions can significantly impact your legal protection and financial liability. In the world of contracts and legal agreements, risk allocation provisions are essential tools that determine who bears responsibility when things go wrong. Today we're examining two of the most common yet frequently misunderstood legal protections: hold harmless clauses and indemnification provisions. A hold harmless clause is a statement in a contract that releases one party from liability for injuries or damages caused to another party. Also known as a release of liability, waiver of liability, or save harmless clause, these agreements appear in many contracts, including leases, easements, and service agreements. The fundamental purpose is to prevent lawsuits from arising in the first place. Hold harmless agreements come in two primary types. Reciprocal agreements occur when both parties agree not to hold each other accountable for damages. Unilateral agreements happen when only one party agrees not to hold the other responsible. Indemnification, on the other hand, is the assurance that one party will compensate the other for any liability, damage, or loss incurred. To indemnify means to insulate another party from financial loss or damages. The purpose is to ensure you receive compensation for losses that were not your fault. While these terms are often used interchangeably, they serve different functions. Many professionals believe indemnity protects against losses, while hold harmless clauses protect against both losses and liabilities. However, interpretations vary by state and circumstance. The key distinction lies in their approach to protection. A hold harmless clause provides the highest level of protection by preventing lawsuits altogether. Indemnification activates after damages occur, ensuring financial compensation for losses. In practice, a hold harmless clause might prevent a business from taking responsibility for a customer's mistake, while indemnification protects a business against claims resulting from customer errors. For maximum protection, legal experts recommend including both terms in contracts. This comprehensive approach ensures parties are protected from lawsuits and will receive compensation if damages occur. In many contracts, you'll see the phrase defend, indemnify, and hold harmless. Each term serves a specific purpose. Defend requires one party to cover legal defense costs. Indemnify compensates for financial losses. Hold harmless prevents legal liability from arising initially. These clauses appear in numerous applications. Construction contracts typically include indemnification clauses where contractors protect property owners against third-party claims. Service agreements often contain provisions where service providers shield clients from liability. Event organizers require attendees to sign waivers releasing them from responsibility. Landlords may require tenants to indemnify them for incidents on the property. Despite their protective power, these clauses have limitations. Some states restrict hold harmless provisions in specific industries, like construction. Courts may refuse to enforce clauses in cases of gross negligence or intentional misconduct. Ambiguous wording can lead to disputes, and third parties who suffer harm may still seek damages despite existing agreements. The enforceability of these clauses depends on clear language defining the scope and limitations of liability. State laws significantly influence how courts interpret these provisions, making it essential to understand local regulations. When deciding which clause to use, consider the nature of risk and desired protection level. Use hold harmless clauses when you want to prevent lawsuits entirely. Choose indemnification when seeking financial compensation for damages. In high-risk industries like construction and professional services, including both provisions offers the most comprehensive protection. Understanding the nuances between hold harmless and indemnification clauses is vital for effective risk management in contracts. These provisions serve as powerful tools for allocating responsibility and protecting parties from financial and legal consequences. However, their effectiveness depends on proper drafting, clear language, and compliance with state laws. For any contract involving significant risk or liability, consulting with a qualified attorney ensures these clauses provide the protection you need while remaining legally enforceable. The small investment in legal guidance can prevent costly disputes and provide peace of mind in your business dealings.